Good morning, everybody. My name is Jeffrey Garcia. I have the honor of serving as the president of this board. This morning, we are meeting at the Department of Consumer Affairs located in Sacramento, California. Today, we will have the designated time on the agenda for public comment for items not on the agenda, and I will also ask for public comment on each item on the agenda as well. I ask that you please be respectful of the need to conduct the board's business, and I want to ask all of us to please turn your cell phones to silent. This meeting is available via WebEx teleconference. However, the board is webcasting the meeting only as a courtesy to the public. And the meeting will continue even if the webcast fails, pursuant to the notice given in the agenda. Individuals listening to this meeting will have the opportunity to provide public comment and will be assisted by the moderator who will be facilitating the teleconferencing process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. The board welcomes public comment on any items not on the agenda, and it is the board's intent to ask the public for comment prior to the board taking any action on any action items. If for some reason I forget to ask for public comment on the agenda item and you wish to speak on that item, please raise your hand and you will be recognized. Today's meeting will be run according to the Opens Meeting Act as required by law. We plan to end today by 4 p.m. As we do at each meeting, before we do roll call and call the meeting to order, I would like to state our mission, vision, and values. The mission of the California State Board of Optometry is to protect the health and safety of California consumers through licensing, registration, and education and regulation of optometry and opticianry. Our vision is for the people of California to receive quality optometric and optical care. Our values are consumer protection, diversity, equity, inclusion, and belonging, excellence, integrity, professionalism, and transparency. Now I would like to call the meeting to order and ask that the secretary please call the roll.
Member Clemens,
Present.
Member Dawson,
Present.
Member Sue,
Present.
Member Moreno,
Present.
Dr. Pruitt,
Present.
Dr. Tedder,
Present.
Dr. Wong,
Present.
Dr. Bragg present, Vice President Linden,
Present.
President Garcia.
Present.
You have quorum?
Okay, we have a quorum. Thank you very much. We have a full house today. Okay, let's move on to agenda item number 2. Public comment for items not on the agenda. The board welcomes public comment on any item not on the agenda. The board will extend 2 minutes or as much as necessary to any speaker to speak on any topic that is not already before the board for discussion today. Is there any public comment from those in the audience? Welcome.
That's the button on the bottom of the base should turn green when it's yellow.
Okay, you can hear me? Yes. I'm Ruby Garcia, the Executive Officer of the California State Society for Opticians. I want to thank Greg and his team. Outstanding how quickly they'll answer our calls because we need help processing applications for our CLDs and our SLDs. They're great, and I truly appreciate Greg and your team. We're also celebrating several optician programs: American Career College, San Mateo Adult School, Martinez Adult School, Sac City, Southwestern, and soon to be opening San Diego City College of Continuing Education. And naturally, we are connected with Chabot College. They have attributed to very positive outcomes of increasing the national pass rate. We are celebrating something very new. Chabot College, fall of 2026, will be opening up Associate of Science Optical Technology degree. And for that, we thank our Governor, Gavin Newsom. It was his foresight to first look at apprenticeship programs. And by that, what he has done, he's helped us open up a degree program. And we especially want to thank Berkeley School of Optometry students. We have several of them, up to 12 of them, who are helping us teach our programs at Chabot College. That's a wonderful celebration. Thank you.
Thank you.
Good morning. My name is Rohit Chopra. It's great to be with you all today at the Department of Consumer Affairs. during my first week as Secretary of Business and Consumer Services. Prior to coming to California, I was nominated by President Biden and confirmed by the Senate to serve as the Director of the Consumer Financial Protection Bureau, which is the federal counterpart to the California Department of Financial Protection and Innovation, where I oversaw the mortgage, credit card, auto loan, and markets for consumer financial products and data. In 2017, I was nominated by President Trump and confirmed by the Senate to serve as a commissioner on the Federal Trade Commission, which is the federal counterpart to California's Department of Consumer Affairs. In these roles, I was fortunate to work closely with attorney generals of California on major issues affecting this state. I want to share with you some background on the new agency that this board sits within, offer some observations about the industry you oversee, and describe in more detail our agency's focus on small and independent businesses. On July 1st, Governor Newsom and I launched the Business and Consumer Services Agency. The new agency serves as an umbrella for dozens of boards, bureaus, and departments, including yours, improving coordination and enforcement across sectors that touch the lives of Californians, from financial services to real estate, retail, hospitality, agriculture, and of course, healthcare. The governor's announcement outlined key goals for the upcoming year. 1, protect consumers and help entrepreneurs and small businesses succeed. 2, crack down on harmful, anti-competitive, and corrupt practices that harm families and businesses. And 3, work to ensure that new technology benefits all Californians. I'm fortunate that Melinda Grant will serve as the agency's undersecretary. She will bring extensive experience across state government, including within the Department of Consumer Affairs. This summer, I will announce additional members of the leadership team, including deputy secretaries. Given the size and breadth of its portfolio of regulatory, licensing, and enforcement activities, the Department of Consumer Affairs will be central to the agency's initiatives. And I'm grateful that Acting Director Lally and her team are playing a major role in the stand-up of the agency. In many ways, it is lucky and fitting that my first week includes the opportunity to come to a board meeting, the Board of Optometry. As a federal trade commissioner, I was fortunate to be able to work closely with optometrists, opticians, and patient advocates. FTC commissioners were responsible for implementing updates to the contact lens rule and the eyeglass rule. I'm sure you're very familiar with those. As you know, these rules ensure that a patient gets access to their prescription without feeling coerced into purchasing eyewear from a particular provider. While these protections aren't perfect, they go a long way to protect consumers and ensure fair competition. Through these proceedings, though, I learned a lot about the challenges faced by practitioners, especially those operating small practices. Many felt bombarded by confusing communications from large companies operating online services, requesting or verifying prescriptions. Many optometrists that conduct a thorough eye exam have struggled to get a fair reimbursement for their services from insurers. The eye care industry has experienced extraordinary consolidation. Some business models commingle vision insurance, clinical practices, and eyewear under one umbrella. We've also seen significant acquisition activity by investment firms like private equity. And while the Business and Consumer Services Agency will be very closely focused on California families and the costs that they face, a key priority will also be to identify ways to support independent businesses and practitioners, including small practices like the one this board oversees. It's critical that these community-focused providers remain viable, especially in areas of California where there are shortages of professionals. And I'm concerned that many small players in the healthcare industry face pressure from dominant actors with the power to dictate decisions that are best left to medical professionals. This also has been the subject of legal disputes, including allegations of unfair and anti-competitive practices. For many independent practitioners, they simply feel forced to sell to a larger player. This has real consequences. Academic studies examining the healthcare industry regularly point to consolidation as a key contributor to higher costs and worse patient outcomes. The California State Board of Optometry and all the boards that we will oversee play a critical role in protecting patients and ensuring affordable access to eye care. But your work is also important to ensure a level playing field between small and independent eye care practices and their larger competitors. Unfortunately, these issues are just not unique to the one you oversee. They are pervasive across the economy and sectors regulated by our agency. And while each department, board, and bureau operates under different statutes, the agency plans to, one, analyze existing licensing policies across the board, especially regarding new business starts and changes in control and ownership. Two, identify regulations that may be skewed in favor of larger players at the disadvantage of new and independent players. Three, determine whether protections for smaller businesses and firms are being adequately enforced. We will be sharing more about this priority and our other priorities to help our departments, boards, and bureaus. We will be eager to hear from everyone about ways we can advance these goals. I look forward to working with the thousands of dedicated employees of the Department of Consumer Affairs and all of the departments within our agency, as well as members of boards like yours. Together, we will have to use our tools to not only protect California families, but to guard against corporate practices that threaten the viability of independent healthcare and businesses. Thank you very much.
Thank you. Thank you, Mr. Chopra. Are there any other comments from those in the audience? Seeing none, we'll open it up to anyone who's online for a public comment.
This is the moderator for members of the public on WebEx. If you would like to make a public comment for items not on the agenda, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Thank you. Okay, let's move on to agenda item number 3, discussion and possible action on meeting minutes. Members, if you've already reviewed the minutes, if there are any corrections or additions to the minutes, please do so now. Otherwise, I'll accept a motion in a second.
I move the minutes.
I'll second.
Okay, at this time, I'd like to open up for any public comment from anyone in the audience regarding the minutes. Seeing none, we'll open it up for anyone online for comments on the minutes.
This is the moderator for members of the public on WebEx. If you would like to make a public comment for agenda item 3, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, thank you. Member Bragg, if you can please perform a roll call vote.
Member Clemens,
Aye.
Member Dawson,
Aye.
Member Sue,
Aye.
Member Moreno,
Aye.
Dr. Pruitt,
Aye.
Dr. Tedder,
Aye.
Dr. Wong. Aye. Dr. Bragg, aye. Vice President Linden. Aye. President Garcia.
Abstain, I was not present.
Motion
Thank you.
passes.
Motion passes. We'll move on to agenda item number 4. I'm going to have EO Pruden go ahead and kick this off for us.
All right. Good morning, everybody, and thank you, President Garcia. This is item number 4, discussion and possible action on the board president's report. First item we have is sub-item A, which is our board officer elections, and just to cover the formalities of it, we are required by statute, Business and Professions Code Section 3014, to elect from within the membership a president, a VP, and a secretary who will hold office for at least 1 year or until the election of a successor. All of the officers can be elected on one motion as a ballot, as a slate. And at our April meeting, we had put into nomination by member Wong the existing officers for a subsequent term. President Garcia for another one-year term, VP Linden for another one-year term, and Secretary Bragg for another one-year term. Those were the nominations received as of the close of the nomination period. And as such, we need to formalize those nominations via a motion and a vote today. Before we entertain a motion and a vote in said item, board officer elections, certainly want to turn it over to the three nominees for any statements that they may want to make regarding the board officer elections.
Secretary Bragg?
I want to thank everyone for their support in the last 2 years of doing secretary, and I appreciate the nomination from Dr. Wong because I do enjoy the role of secretary, and I appreciate the support from all the members.
Member Linden?
Thank you also for the nomination. Yes, I would be very happy to continue serving in this role. I've also enjoyed being in this role, and yeah, love to serve. Thank you.
Okay, so I was absent that meeting. That's why I got nominated. But I appreciate the vote of confidence. It's been an honor to serve as president of this board. You're all very talented, intelligent, and smart people. So it's really a privilege to be here and serve as president. It would be an honor to serve one more year. Having said that, we're definitely going to encourage all members to consider moving up into positions of leadership. Again, it's very rewarding. We all know each other. It's a fun board to participate in. And we look forward to our next president and any additional members that may want to step up into these roles. So thank you. At this time, we'll accept a motion and a second.
I motion to approve our officers.
A second.
I'll second it.
Okay. Are there any comments from those in the audience? Let's open it for any comments for anyone who may be calling in.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Thank you. Okay, Member Bragg, if we can do a roll call vote.
Member Clemens,
Enthusiastically, yes.
Member Dawson,
Yes.
Member Sue,
Yes.
Member Moreno,
Yes.
Yes.
Dr. Tedder,
Yes.
Dr. Wong. Yes. Dr. Bragg, aye. Vice President Linden. Aye. President Garcia.
I vote aye.
Motion passes.
Motion passes. Thank you.
Yay.
Okay, let's move on to discussion B, which is discussion of possible action on board committee assignments. I think all members have reviewed the different committees and work groups. And what you see in front of you is the current makeup. And going forward, it doesn't have to stay this way. If you'd like to remove yourself from a position or add yourself as a nominee for the position, we can do that now. So we'll start. Go ahead.
Yeah, I just wanted to, just a couple comments. You see in the meeting materials, there are some existing vacancies, and I would certainly love to try to achieve, at least get some comments from you all about those existing vacancies. Looking forward as well, however, we know for sure that Member Wong will have to depart by June 1 of 2027, and she is the chair of 2 of these committees. So that's something that I want the members to think about as well. You know, the most active of the committees that she is chair of would be the Practice and Education Committee. And I know we've got good experience with the other 2 members there, but just in terms of leadership, right, in terms of continuing, you know, that going forward, that is something that I think we should think about, knowing that she is going to have to term off a year from now.
Sure.
I am for sure this time, yes.
So we'll take it one group at a time, and we don't need to spend a lot of time on this. It does not require a motion or anything like that, but I can make a list of members that you would like to either place your name or remove your name from a particular work group or committee. So we'll start with Children's Vision Work Group. Would anyone like to volunteer to serve on that work group?
I'll volunteer to serve on that one. You have to take me off of some other ones.
We'll have to take you off. Yeah, exactly.
Member Sue, are you good?
Yes.
Okay. Anyone else? Okay, seeing.
Yeah,
Yes,
yeah, put me on there too if you don't mind.
okay, we'll do.
Bless our kids.
So just as a word of, as President Garcia mentioned, we can get a list of interests today. We don't need a motion and a second and a vote to establish committees under President Powers. He can change the makeup. I do just want to make a note though, however, work groups do have to be limited to 2. The moment they become 3, they become a committee. So that's just something that we can talk about subsequent to getting everybody's interest today.
Consumer Protection, Public Relations, and Outreach Committee. Would you like to add or remove your name?
If I may, just a couple cleanups on here under consumer protection and also under practice and education. Our colleague Joe Pruitt needs an extra T in his name.
You're right.
And while I appreciate the promotion to being an attorney, which I am most decidedly
That's
not.
also not true.
Yeah. Thank you. I play one on TV from time to time, but I defer to Brendan for all of my actual legal actions. I enjoy being on this committee and be happy to stay put.
Okay, thank you. Would anyone else like to volunteer? Okay, seeing none, we'll move on. Ledge and Reg Committee. Would you like to remove your name or add your name?
I would volunteer for this one.
Okay. This might be one where, again, Lillian is chair. Is there anybody that's on the committee now that would be interested in stepping up into that role? There's obviously a possibility that Lillian could drop off that committee. Tedder could take her spot, but then we would need a new chair. So again, just different combinations that we can play with.
Okay, next one is NBO Arbo Work Group. We have a vacancy.
I would be interested in serving in that work group.
Awesome.
Thank you, Andrew. Anyone else? Okay, seeing none, we'll move on. Optometry and Optician Practice Act Work Group. Okay, we'll move on. Practice and Education Committee.
I can volunteer for this one as well.
Wonderful.
And Telehealth and Emerging Technologies Work Group.
As a public member, without the specialized expertise other members have, my utility on this work group is modest. And if one of my professional colleagues had any interest on joining this group, I would be more than happy to step off of it or stay put as the board sees best fit.
Any members interested in participating?
I'd be interested in this one.
Thank you, Joe.
Okay. I appreciate everyone's enthusiasm and participating in these work groups and committees are very important in conducting our board business. Are there any comments from those in the audience regarding this topic? Seeing none, let's open it up to online.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Thank you. Okay, we're at now at 9:24. We have a 9:30 time certain start for our closed session.
Well, not for closed session, but for the oral
I'm sorry.
hearing. So I think with about 5-6 minutes until the time certain start of 9:30, good chance for anybody to go use restroom if you need to. I think we may have to do a little bit of infrastructure changes up here at the dais. So why don't we pause here, and then we'll come back, be ready for 9:30 time certain.
Okay, sounds good.
That
Thank
work,
you.
Council? Yeah.
Okay, we're moving on to agenda item number 5, which is oral argument hearings in the matter of the accusation against Dr. Ashkan Alizadeh Respondent, agency case number 420-2025-000-286, OAH number 202-504-0355.1, originally OAH number 202-504-0355. Judge.
Thank you. All right, so we have a court reporter today, so let's go ahead and go on the record. So we're on the record before the California State Board of Optometry, Department of Consumer Affairs, State of California, in the matter of the accusation against Ashcon, ASHCON, Alizadeh, ALIZADEH. It's agency case number 420-2025-00286. And it's OEH number 2025-040-355.1. My name's Corin Wong. I'm an administrative law judge with the Office of Administrative Hearings, and I'm sitting here with the board. Madam Court Reporter, did you want to make your statutory statement for the record at this time?
Maria Esquivel Parkinson, CSR number 106.
Thank you. And just to establish quorum for the record, if each member would respond after I call his or her name. President Garcia? Vice President Linden?
Present.
Secretary Bragg?
Present.
Dr. Pruitt? Mr. Stu?
Present.
Dr. Wong?
Present.
Mr. Clemens?
Present.
Mr. Dawson?
Present.
Dr. Tedder?
Present.
And Mr. Moreno?
Present.
Thank you. Let the record reflect that a quorum of the board is present. So we're here for this matter originally came to hearing before an administrative law judge with the Office of Administrative Hearings. The ALJ issued a proposed decision. The board issued an order rejecting the decision and indicating it was going to decide the matter based on the record, ordered the transcript, and then subsequently issued an order clarifying that it was going to set oral argument and receive evidence. So we're here for that portion of the hearing. If I could take the appearance of counsel, starting with counsel for complainant.
Good morning, Philip Arthur from the Attorney General's Office.
Good morning.
Yes, and Jonathan Turner on behalf of the complainant, Dr. Alizadeh. I need to press something?
Yeah, just push it once and it should turn green. It's on.
Push what?
The bottom.
Oh, okay. Thank you. Sorry. Attorney Jonathan Turner on behalf of the complainant or the respondent, Dr. Alizadeh,
Okay.
is present next to me as well.
Great, thank you. Are there any preliminary matters? I think, Mr. Turner, you mentioned, I guess, a procedural matter you wanted to raise?
Yes, thank you, Your Honor.
Okay.
Yes, this matter was, the order in this matter was initially to reject the decision and then to decide the case based on the record, the transcripts from the hearing. And I was sent a document from the board saying, do you want oral argument? This was back in March, I believe. And I responded right away and said, yes, we'd like to make oral argument. That's why we're here today. It appears now that the board or complainant's counsel wants to include additional evidence or provide additional evidence. That was not the initial order from the board, and we're here because I requested oral argument. I wasn't given the opportunity to present additional evidence. I was told if you want oral argument, which is typically how these work, you can show up today. Nothing about providing additional evidence. Had I been told, oh, we're going to use this as an opportunity to reopen the record and fix so-called problems that we had at the hearing, I wouldn't have requested us to be here today. I would have relied on the record that was presented at the hearing. And so that's my concern. And in fact, the court stated, and this was, you may be aware of this, Your Honor, when the board requested your presence, the Office of Administrative Hearings stated that they would allow you to be here, but they stated in their order, and they concluded it this way, the board's order stated it would decide the case on the record and upon, and quote, and upon such written and oral argument as the parties may wish to submit, end quote. The board did not invite additional evidence, though complainant now states an intention to produce it. Whether the board approves of complainant's uninvited intention to produce additional evidence at the oral argument is not for OAH to determine at this time. So basically, I think what OAH was saying that here we are today, and it's clear that this is only to be oral argument and not the presentation of additional evidence. That's certainly not what we requested, which is again why we're here. So I would conclude with that.
Mr. Arthur, do you wish to respond?
Just briefly, Your Honor, the order setting today's hearing expressly references the fact that additional evidence can be received. Government Code, Section 11517, subdivision C2, E as in Edward, which is what this the hearing today is proceeding under, expressly allows for the consideration of additional evidence. And then also within the order from, I believe it was Judge Rowan that was referenced by Mr. Alizade's counsel, the court cited to that subdivision, noting that additional evidence, that it does mention that additional evidence can be received at such a hearing as this. And I believe it also, I apologize, I don't have it in front of me, but I believe it also cited to case law in which additional evidence had been received before, hence why Judge Rowan granted your presence today. Thank you.
Okay, and just, I understand, Mr. Arthur, you're going from memory of the order, so I'm not faulting you for this, but just to clarify, in the case cited by Judge Rowan, no evidence was offered, and that's why the court found no due process violation. So it was a little almost like the opposite of here, in that there was a hearing for oral argument only, and no hearing officer was present, and the board in that case ultimately revoked the license. The licensee petitioned for a writ of mandate in Superior Court, which was denied, and on appeal before the District Court of Appeal, one of the arguments was a denial due process because a hearing officer wasn't present. But thank you, I am familiar with that. As well as all the orders. Mr. Turner, when did you first receive notice of the possibility that Mr. Arthur would want or wanted to introduce evidence?
He never provided me with anything saying he was going to introduce new evidence. He could have shot me an email. We have corresponded via email many times throughout the months or years this case has been going on, and never once did I get an email or a phone call saying, oh, by the way, I'm going to present additional evidence in this case.
Did you receive a copy of his motion for appointment of an administrative law judge?
Yes, I did.
Okay, well, in that motion, didn't it indicate that he was going to introduce two pieces of evidence?
I'm not sure. No, it did not mention two pieces of evidence. I don't remember any reference to that. In fact, I thought it maybe said something about there would be oral testimony, is my recollection, which I assumed was the oral argument.
So, just so I understand, when did you first learn that Mr. Arthur was intending to present documentary evidence.
Today.
Mr. Arthur, is there anything else you wanted to add?
Your Honor, again, I'm sorry that I don't have these documents in front of me. My recollection of the brief that I filed with the Office of Administrative Hearings expressly referenced that I would have an individual testify today and that the two documents attached as exhibits to the written argument I submitted would be offered today.
And that's consistent with my recollection. In fact, that's the whole, I guess, underlying premise of Judge Rowan's order, is that evidence might be produced. So let me see if any board members have any questions on this procedural issue. And just to clarify and to make sure everybody understands what the issue is the original order from the board indicated oral argument would be heard. There was subsequently, yes, oral argument would be heard. There was subsequently a motion by Mr. Arthur to have an ALJ from OAH present at the hearing. And that order or that motion was granted. The board subsequently on June 2nd, 2026, issued an order clarifying that oral argument and evidence would be received at today's hearing. And so, but Mr. Turner is objecting to.
Oh, I'm sorry.
Go ahead.
There was one important thing I'd like to add,
Sure.
if I could, that I want the board to know is we are here because back in March, and I can provide the emails, the board sent me documentation saying, if you want oral argument, let us know. Nothing about presenting additional evidence or reopening the record so that we can sandbag you as they're trying to do now. I said, yes, we'd like to come before you and make an oral argument. That's what we wanted. That's why we're here. Had I been initially told, oh, we're going to reopen the record and we're going to find, hundreds of pages of documents and go from there and try to, we think, fix problems with our initial case, I would never have requested that. And so that's the problem I have is we're here because I requested oral argument. I didn't request, oh yeah, let's present additional evidence.
All right, thank you. So, and I was going to add that, but Mr. Turner did it succinctly and well. So that's the issue presented at this moment. And I first wanted to check to see if any of the board members had any questions for council or anyone else.
Secretary Bragg, I have questions. With the option, there are 5 options for his non-adopt of a decision. I believe the option of oral argument says with or without additional evidence. And then also looking at the complainant's written argument on non-adoption, the DAG outlined that there is additional evidence, and that looks like it was dated April 2nd. So I'm confused as far as not being notified about additional evidence.
Mr. Turner, did you wish to respond?
I'm sorry, the DAGs.
Complainant's written
Right,
argument on non-adoption.
right.
Page 4, line 21, additional evidence establishes. And then
Right.
on page 6, it has the date of April 2nd.
Yeah, I understand that. I see that it's mentioned. I would also argue that written argument for non-adoption, you're supposed to rely on the record, meaning That's why they provide you the transcripts. That's why we wait for the transcripts. So
Correct, but your testimony was that you had no knowledge of evidence that the DAG was wanting to submit additional evidence.
I did not know they were going to present that. I see it was attached to that, and I absolutely believe that was improper for that to be attached to that. And I'm not saying I didn't see these documents before, but what I'm saying is it's news to me until today that they were actually going to try to put those in at the oral argument today.
Great. Are there any other questions from any other board members?
Yeah, I don't have a question, just a comment, but I do recall that the board amended the order and issued it June 2nd. So at that point, we were requesting additional and oral arguments.
Correct. And I guess my response to that is it's sort of moving the goalposts, isn't it? I mean, you issue an order saying we're just going to have oral argument. If you request it, if you, Mr. Turner, you responded, request it. We requested it. It's a, you know, and now you're going to change it up and say, oh, you've requested oral argument. We're all going to be here. Oh, and now we're going to present additional evidence against you. I think that's the unfairness I see in this. You could do that every time. If you want to get in new evidence, you could say, well, we're just going to do oral argument. What do you say, counsel? Sure, we'd love to come before you people and make our arguments. We feel strongly about our case. And then down the road, you say, oh, and by the way, we're going to now include additional evidence to use against you. That's the unfairness I see in it.
This is Member Linden. I have a specific question.
Sure.
So if, I know right now we're talking about oral argument kind of generally, and then this particular point of additional evidence. But if we have oral argument at this hearing, does that include an opportunity to converse with the respondent? Or does that fall, you know, if the board wanted to, wanted to ask questions and hear some answers, would that fall within oral argument, or would that be considered additional evidence?
So oral argument is just argument, and case law is clear that argument is not evidence. So if the board wanted to hear additional evidence, whether it was a testimony of a witness or receive a document or both, that would fall under the gamut of additional evidence, which the June 2nd order did indicate would be received. It wasn't limited to, for instance, the documents Mr. Arthur mentioned in his motion. It just said evidence. Does that answer your question? Okay, great.
Thank you.
Any other questions from anyone else on the board?
Yes, I have a question, Your Honor. I guess my question, Mr. Turner, is given the predicament that we're in, and I can understand your rationale, is your current request to perhaps reschedule this or continue this matter so that we can come back and be prepared, or what is your current position for today's hearing?
I mean, it's a good question. I mean, my current position is OAH's most recent order was they're kind of leaving it in, I think, your hands as far as whether you want to accept this or not. They seem to imply this isn't really fair, but they're leaving it up to you. But I mean, my first request would be, we're here today. Mr. Alazadeh flew in from Texas to be here today. I'd prefer to deal with this and not have the evidence come in, because again, that wasn't our expectation. And I don't think it's fair. But if that is going to be the board's position, then yes, I would ask for additional time.
All right, Mr. Arthur, anything further you'd like to add?
Just briefly, Your Honor, just from a due process concern, which I guess it's kind of what Mr. Alizade's counsel is trying to raise. Again, as the Secretary Bragg pointed out, council has had notice since April of the fact that additional evidence would be introduced in the form of these documents. And then within the motion that my office filed, requesting your presence at today's hearing, which was over a month ago, it expressly referenced the fact that there would be witness testimony and exhibits admitted. So I believe from a due process perspective, as far as council having notice to be prepared for the offering of additional evidence and the fact that additional evidence would be considered, which was also noted within the order setting today's hearing, there has been more than adequate notice, and that's my final point. Thank you.
All right. So thank you both and council and the board members for the questions. So based on all the documents, I did just check Mr. Arthur's motion for an ALJ to confirm my recollection that he indicated he would seek to admit documents. I did confirm he did mention that. And also Judge Rowan's order is premised on the possibility that evidence would be offered. If it was clear evidence was not going to be offered, it's clear from her order that it would have been a different outcome. The case she cited, let me pull it up so I could cite it. She specifically cited Yankee, Y-A-N-K-E, versus State Department of Public Health. It's a 1958 case, 162 Cal-App 2nd at page 600, starting at 600. As I mentioned earlier, in that case, proposed administrative law judge heard the initial matter, issued a proposed decision. The board rejected it and set the matter for oral argument. And after oral argument, ultimately, or I should say the proposed decision was to place the license on 5 years probation. After oral argument, the board revoked the license. And on appeal, the petitioner or licensee argued a violation of due process because a hearing officer was not present during oral argument, and the appellate court concluded that there was no violation because a hearing officer is only required when evidence is going to be received or a question of law is going to be decided. So I think there's notice at least no later than Mr. Arthur's motion. There's no notice in the Judge Rowan's order, and there's further notice in the board's June 2nd order. So based on that, the objection to receiving evidence, additional evidence, is overruled. So if I understand you correctly, Mr. Turner, you're now requesting, given the ruling I just made, you're asking that the matter be continued. Is that correct?
That's correct. And in the alternative, we'll just withdraw our request for oral argument and we can all go home. It's the reason we're here. That's what I requested, and that's why we're here.
All right, Mr. Arthur, your response to, I guess, the motion to continue and or alternatively, I guess it's motion to continue or in the alternative to withdraw the request for oral argument.
I would have no objection to council's request to withdraw his request for oral argument. Regarding the continuance, complainant would argue there is not sufficient good cause. There's also the timing requirement for requesting continuance. And so as far as the timing continuance, which I believe is 10 business days under the government code, as I've previously pointed out, and I think the court noted as well, there has been more than 10 business days notice for counsel regarding the fact that additional evidence would be offered here in the form of witness testimony and exhibits. And so the request is late, and then kind of piggybacking off of that, that's not sufficient good cause. Hasn't been demonstrated any good cause for a continuance, again, because there has been adequate notice as to what evidence would be offered at today's hearing. Thank you.
Thank you. Mr. Turner, anything further you wanted to argue?
Yeah, just that, again, OAH's order about this implies that this is only going to be about oral argument. Yes, they had you come here, but they seem to imply that, you know what, the original order said this was just for oral argument, and that's it. Again, I can't emphasize enough how I believe it is absolutely improper, and I think an appeals court would agree. You can't issue an order rejecting, saying this is just going to be oral argument, and then down the road decide, oh, you know what, and have us then request oral argument, and then down the road say, oh, you know what, now we're going to present evidence now that you've requested oral argument. I think that's the biggest problem here for the complainant in this case. And I think that's what Judge Rowan's order implies if you read it. But other than that, yeah, that's what I would have to say.
Okay, thank you. Are there any questions on the request for continuance, or in the alternative to withdraw the request for oral argument from any board members?
Identify yourself, please.
Yes, of course. This is Member Moreno, and this is to you, Mr. Turner. Even though that there may be a discrepancy about what notice was provided, as the DAG indicated, that he does have, as I understand, a witness and some additional evidence to submit. Did you receive like a hearing brief or a witness list or an exhibits list to specify exactly what the DAG was going to showcase? So that
No, in fact, that reference to the witness, I guess, that was in one of the briefs to OAH doesn't even, I don't believe, say who the witness is going to be, nor did I ever receive any notice, oh, we're calling this witness, and typically you would give the person the name in advance, you'd give them an idea of what they're going to testify about. I have no idea what this person is going to come before you and say.
Okay.
Any other questions from the board? Right, so I don't know if the board wants to discuss this or how the board wants to proceed.
Judge, can you give us some options?
So, yes, I can. Thank you. So, I guess if staff council, board council has something to add, I'm not quite sure of the rules in terms of, can we go to closed session now to discuss this issue, or if that wouldn't be allowed. If we cannot go to closed session, or I guess where I'm going is, if the board wants to discuss the two requests, I would recommend it be done in closed session if that is a possibility. Beyond that, there's a request for continuance. The one concern I have with a continuance is under, and I have the code up, so I'll just, to be clear, under Government Code 11517, subdivision C, and then it's 2E 4, when a board non-adopts a proposed decision and elects to decide the matter itself, its final decision, as applicable here, since the transcript was ordered, is due no later than 100 days after receipt of the transcript. The provision does allow a further continuance of up to 30 days if there's special circumstances, and the board did find those circumstances, and I believe it was in the June 2nd order, extended the 100-day deadline to July 20th, 2026. So my concern is if we continue the matter, a final decision may not be issued by that deadline. And the statute is not clear what happens if the deadline for the final decision is not met. I do note that it contains mandatory language in terms of it says shall. However, in the other provision pertaining to a proposed decision, initially, it indicates the board has 100 days to act on it. And if it doesn't act within the 100 days, the proposed decision is adopted as a matter of law. So the provision for the situation we're in here does not have that clear language. So it's not real clear what would happen, and that would be my concern if it's continued. Normally in a, when faced with a situation such as here, where one party is saying that they didn't know there was going to be evidence, and if evidence is going to go forward, they want a continuance. That's often the easiest solution or the best solution, as opposed to excluding the evidence. But here we have the competing idea or the competing interest or requirement of the deadline for the decision. So I think those issues need to be considered. With regard to the request to withdraw the request for oral argument, I'm not aware of any authority either way allowing a request to be withdrawn or not allowing a request. But assuming a request to withdraw oral argument can be made, then it would be up to the board as to whether they want to accept the request. If the request was accepted, then the hearing would be moved, because there's no longer a request for oral argument unless, I don't know if there's an issue of, since the order issuing oral argument and receiving evidence has already been issued, maybe it can't be withdrawn. I don't know. So those are the issues I'd suggest discussing.
Judge, I have a question. Is it an option to, now that the board has reviewed the transcripts and reviewed the respondents and the complainant's written arguments, could we go into closed session and make a decision?
So in other words, not take
Correct.
evidence.
Yes.
I guess I'll answer the easy part first. And the easy part is the board could not go into closed session right now because we would have to, the board would have to hear oral argument.
Mhm.
Well, I guess, let me say, yes, the statute says that you do have to hear oral argument. So you would at least have to hear that. Whether the board can, in effect, amend its order allowing the receipt of evidence. Before you do that, you probably would want to take oral argument. But ultimately, I think the board can amend its order. And that's in effect what it would be doing.
Okay. Another couple of questions. So it sounds like Mr. Turner was provided information about possible additional evidence and testimony, maybe not with specifics. Is it safe to say that did happen or did not happen?
I'm confident based on the documents I've seen that it did happen.
Okay. So is that not sufficient evidence then to go ahead and move forward into the plan of oral arguments and additional evidence?
I think that is where it comes down to discretion, and so it would, depending on the decision maker, how they view that. Was it enough notice? It's not a clear cut.
That would be your decision.
Right. Yes, I would like the board's input, because I think this ultimately the board's writing the decision. So this is a little different procedure than when an ALJ is normally here. Normally, when an ALJ is here, it's on a petition for reinstatement or termination of probation, and the ALJ would write a proposed decision for the board. Here, I'm here solely for the issue, for the legal issues, evidentiary rulings, and questions of law, and the board's counsel will ultimately write the decision.
Right. So one more question. So just so we know our options, is there an option then to move forward with just oral arguments and then not allow new evidence and testimony and then move into closed session?
I believe, again, I believe there is. I would suggest that we invite argument on that option before, and hear from the other board members as well. But ultimately, I believe the board could, in effect, amend its order by not allowing evidence.
Today?
Yes.
Okay. So those are our options.
Yes.
Are to move forward with new testimony, new evidence, oral arguments, go into closed session, or to amend it and just only allow oral arguments and go into closed session.
I guess a third option is to grant a continuance.
We're just trying to avoid that because timing is critical.
I was going to say, if you do that, you would want to ask, I would say you would only want to continue the matter if respondent was willing to waive time for a final, if both parties were willing to waive the deadline for a final, for the final decision. I'm not sure that can be done. If in other words, if they did that, agreed, I don't know if that would withstand appeal, but I certainly would not recommend, I guess I should say it this way, I would recommend not granting a continuance without at least seeking that type of agreement.
At this point, can we open it up to board comment or discussion?
If you want.
I have a question.
Oh, go ahead.
Mr. Alzadeh, thank you for appearing before us today. I think our intention was to hear directly from you about this matter, and I know that it's gone on for quite some time, and you've had a a big expense to come out here today, so we appreciate you being here. As a point of clarification, now that we have had access to the transcripts, would oral argument include being able to ask Mr. Elzadeh questions on the transcript, or would that fall under new evidence? I'm just trying to get some idea of, if we were to proceed with oral argument only, what are the guardrails that we have to be able to hear from him directly?
So I'm not trying to be cagey or lawyer-like in answering it, but ultimately, I understand the intent of your question and what you're really asking. You would not be able to ask questions if it's just oral argument, and let me explain why. Technically, you could ask questions, he could answer, but you can't consider his answers because his answers would be evidence. So that's why I say it that way. So yes, technically you could ask questions. You just can't consider answers. I would suggest that questions not even be asked, because then you get into the issue of there's extrajudicial evidence, and the old saying that you can't unring the bell once you hear it. Does that answer your question?
Yes, it's helpful. So oral argument then would be exactly what? What would that look like?
It would just be someone, so the easiest way to explain it is you take the evidence and you apply the law to it. Or a short way is arguing or explaining why you win, why the party who presents oral argument wins, or the outcome should be what that party wants.
Thank you.
Okay. Any other questions from the board?
Member Dawson, just a quick clarification question, excuse me.
Oh, please.
So we cannot move forward without oral argument. So the request to withdraw the request for oral argument isn't something that we're even going to consider, correct?
No, and I understand why you are thinking we can't go forward without oral argument. I apologize, I didn't provide the proper context for when I explained that. Basically, if the board is going to make a decision, ultimately make a final decision, then you have to have oral argument. But if the board were to grant Mr. Turner's request to withdraw oral argument, it would be as if he never requested oral argument, and kind of like today never happened. So we would just grant it and then go on to, the board would go on to its next business, if that makes sense. This matter would be over.
So can I just clarify? So if we were to grant the no oral argument, then we wouldn't be able to go into closed session today to discuss this matter. And with the July 20th deadline approaching, I think that would be kind of an issue. Plus, this has been going on for so long. So I don't know if Dr. Elizadeh would want something decided before July 20th. Otherwise, it reverts to what was already the proposed decision. So I guess I think for all of us, we would like to be able to have a board discussion about this matter. I would appreciate a conversation with Dr. Elizadeh about what happened, but I understand that that's, I guess, new evidence. So I think we're kind of stuck, because I think we do want to go into closed session to discuss this. I'm, like I said, most concerned about the July 20th deadline. So if we don't hear oral argument today, we cannot go into closed session. We have to decide this by July 20th. Otherwise, proposed decision is what's decided. Is that correct?
It's unclear, the last part about the proposed decision going into effect. But thank you for your comments, because it made me think about this a little more. And and take a look at another, at the statute more carefully. I do not believe the board has the option now of, well, actually, here's what I was thinking, that the board doesn't have the option of granting the request to withdraw oral argument. But as I look at it more carefully, that might not be the case. Again, I'm looking at 11.517 subdivision C to E double I, little I, and it states, quote, "The agency itself shall not decide any case provided for in this subdivision without affording the parties the opportunity to present either oral argument or written argument before the agency itself." Close quote. So at first I was initially thinking that means you have to hear oral argument, but actually it's just saying you have to give the opportunity. So you did give the parties the opportunity. Complainant did not make a request, but respondent did. And so now the issue is whether or not the board can grant respondents' request to withdraw that request and go forward. Yes.
I have an additional question. So if we, because part of it is either oral or written argument, and we received the respondent's written argument regarding board's rejection of proposed ALJ decision, which I'm sure we've all read, how do we unring that bell as far as considering if we're not going to be considering an oral argument because it was oral or written? What do we do with that document?
So I think the written argument can be considered. Mr. Turner, if I recall correctly, you're withdrawing your request for oral argument, correct?
That's correct.
Or is it withdrawing your request for any argument?
For all argument. I
Okay,
mean, oral argument is what we had come here to do, but if that's somehow opens the door to putting in new evidence, which wasn't our intent in requesting this, then
Yeah, let me clarify. Are you requesting to withdraw your written argument?
no.
Okay.
But I will say this, their written argument includes evidence beyond what was presented at the hearing or was in the hearing record. That's improper. You can't do that. The whole point of written argument at that time was to address the evidence at the hearing and give your side as to why you think the judge was wrong in their decision. You can't then put in new evidence and say, oh, the judge was wrong, and here's new evidence, by the way, that the judge never saw. So that's a problem with their written argument.
And I'm confident the board will be able to handle that issue. It unfortunately isn't at evidentiary hearings. It's not necessarily uncommon to receive argument not supported by the evidence. So that, I mean, that's basically what it would amount to. So to answer, Madam Secretary, your question, you could consider the written argument because it's the request for oral argument that is being withdrawn. Okay. Are there any other questions? All right, not seeing any. I guess check with board counsel. Can the board adjourn to closed session now to decide? Okay, let's go ahead and go off the record. Yeah.
I feel comfortable with the board going into closed session to discuss this matter, and then maybe we can come back and rule on this issue before. Or does that seem?
That's. Do you want to do that or?
So you're proposing to go into closed session just to discuss, to move forward?
The two requests, yeah.
We will discuss. Let's do that.
Sure.
Mr. Chair, if I may, Alex Clemens for the court reporter.
Yeah, no, we're off the record.
The members of this board, with 2 or 3 exceptions, are not attorneys, though we've all played one on TV from time to time. The 2 of you are. The course we take has different outcomes that could be litigated to yet some further higher authority. And I'm wondering, before we go into closed session, given that 100% of us are not well-versed in the law and 100% of the two of you are, whether there is any middle ground, whether the two of you could go to the back of the room and fight out a new area of combat and come back and present it to us and say, this is what we have agreed we should do. If there is no possibility for that, I understand, and we can make that decision. But if there is, I would suggest the two of you are perhaps better qualified to define what that battleground might be than the rest of us. Thank you.
Council, did you want an opportunity to meet amongst yourselves?
Your Honor, I'm always happy to try and reach amicable resolutions and kind of an agreed upon battleground, as it's been referred to. I think this one is pretty clear cut, though, of the parties' positions, that complainant would like to offer additional evidence and the respondent is opposed to that. I don't think.
Understand.
I'm sorry.
Mr. Turner, did you wish to respond?
I think I agree with that. And I just wanted to mention, you mentioned the order extending the 100-day, since you brought that up, and I looked at the order, which is the most recent correspondence we received in this case. I think it was June 2nd, where the board granted itself an additional 30 days to issue a decision in this matter. And I'm looking at it, and it says you have to have special circumstances to give yourself the additional 30 days. And the special circumstances, and whether these would cut mustard in front of an appellate court or not, I don't need to address, but it says, being that the board requires additional time to find a date on which all parties are available to conduct oral arguments. So it says, again, we're looking for a date for oral arguments. Says nothing about intent to consider additional evidence.
Okay, so thank you. Shall we?
We'll move into closed session.
Okay, so I'll turn it back to you, Mr. President, to
Okay, we
procedure.
can vacate the room. We're going to go into closed session. Okay, we're going to go ahead and go into closed session. We'll vacate the room and we'll reconvene. And do we have to give a time certain?
I'm not sure.
We'll reconvene in 15 minutes. Okay.
Okay, all right, so let's go ahead and go back on the record. So let the record reflect that all board members who previously stated their appearances on the record have returned to the dais. And so we do have a quorum. So after discussing this matter, this is the rulings I'll make. With regard to the request for continuance, the request is denied. And then the request to deny, or the request to withdraw the request for oral argument is also denied. But we're issuing a new order or amended order, not allowing any new evidence. We'll just take oral argument from the parties and proceed that way. So with that, anything else that any of the board members wanted to add? Not seeing anything. So with that, Mr. Arthur, if you'd like to present your oral argument.
Thank you. In light of the board deciding not to take additional evidence, I will rely upon the written argument which I submitted. Thank you.
Thank you, Mr. Arthur. And you remind me, something I did forget to mention is that we did receive, the board did receive written arguments, so there isn't a need to repeat it. But of course, if you want to highlight something, you're welcome to do so. Mr. Turner?
Yes, thank you. I've also provided written argument, as you're aware. I would point out that the written arguments are written argument, and that means that you don't present new evidence. It's not testimony or evidence, the written argument. And what complainant tried to do is introduce new evidence into their written argument. And then after I had and this was all done after I had requested oral argument, and then they tried to get that evidence, probably knowing they couldn't get it in via the written argument brief, tried to get it in here today. But I just think it's important to point out, and you probably already understand this, you can't consider new evidence as part of those written arguments. The whole point of the written argument is to address the evidence at the hearing, the exhibits, the certified transcripts, and consider those and then argue as to why the judge did or didn't make the proper decision. And I think just to emphasize a few things, the judge in this case is a very prominent and highly respected judge in the area. And I think his decision's really unimpeachable. He said, among other things, that Dr. Alezadeh was credible when he said, and I'm going to page 7 of his decision, but he stated that respondent being Dr. Alezadeh, credibly testified that he believed he was a licensed optometrist based upon the language in the statement of licensure. He did not know that he was unlicensed until he received the accusation. And so that observation by the judge is almost unimpeachable based on case law as well as statutory law, which I cited in my brief, meaning you have to give great deference to the trial judge's observations on credibility. And Dr. Alezadeh was subject to cross-examination by Mr. Arthur, who's a seasoned attorney, and answered questions, again, in the judge's opinion, honestly and testified credibly. So you can't go back on that and say, as a group, and you know, with all due respect, you can't sit here today and say, oh, well, we don't think he was honest based on whatever we're reading or looking at. Again, the judge was the one who got to observe him testify and made those observations. Another couple of important points that the judge pointed out in his decision was that Dr. Alezadeh has expressed his desire to give up the statement of licensure. He made that very clear. I think it expired quite some time ago. He, as soon as he found out, received the board's accusation that he wasn't to practice, he informed his employer right away that, you know, he couldn't practice. And so, and that's important as well, based on the case law that the judge cited in his written opinion, saying if the person's willing to forfeit the license, there's really no issue. You let them do that. And then I think another important point that the judge pointed out in his decision is that this board's duty, as you're well aware, is protection of the public. And number one, you can't practice with a statement of licensure. And number two, Dr. Alezadeh has indicated he doesn't want to practice with he wants to give up the statement of licensure. He doesn't even, it's not even valid anymore, and he's happy to give it to you. And so that more than amply protects the public, which again is what, you know, why people exist, is protection of the public. So we don't have to worry about that. And again, you had testimony at the hearing from Mr. Garding stating that the board certainly can just cancel a license. He stated that at the hearing. Yes, it can be done. He said in this case, because an accusation, I think, had been filed, it was too late for some reason, but it didn't quite make sense. And at the end of the day, it's very clear that I don't think there's any dispute that Dr. Alezadeh received the statement of licensure by error of the board. And at hearing, there was testimony from Mr. Garding that there were, I guess, certain processing errors that existed at the board that have since been fixed. So this sort of thing doesn't happen again. And that's very good. And that's a net positive in this case. But The problem with revoking his license, as I think you're well aware, is that if he's revoked, revoked for a license that was issued to him by error, then that's something that will go to the National Practitioners Database. Again, Mr. Garding confirmed this when he testified at the hearing, and that's going to impact Dr. Alazadeh for the rest of his career. There's going to be this black mark on his record with the Practitioners Databank that he had a license revoked. And I don't think people who look at that are going to care whether it was because it was issued in error by the board or not. They're just going to see a revocation, and that's going to impact his career moving forward. I think he indicated at hearing that he does want to practice eventually in some state in the future, if and when he qualifies. And it's always going to come up that, oh, you had a license revoked, and he's going to have to explain, well, it was issued in error. But I think at that point, it's going to sort of not matter. So, and so it would really be grossly excessive punishment to revoke a license that was issued by error of the board. I do hope you will ultimately come to the same conclusion as the administrative law judge in this case. I know Dr. Alazadeh had a statement he was going to make, but I don't know if that's permitted or not. But I would leave that up to your honor, whether he's able to just make a brief statement.
So, given the rulings, I'm not going to allow him to make a statement, just so we don't have potential issues of evidentiary matters in it.
Understood.
Right?
Okay.
Did you finish your?
Yes, I did. Thank you very much.
Mr. Arthur, complainant has the burden in this matter. Did you wish to argue anything on rebuttal?
No, again, Your Honor, just to reiterate to the board, when they review the written argument, it addresses how the evidence established at the hearing itself establishes all four causes for discipline within the accusation, which warrants revocation of the license. Thank you.
All right. Thank you both, counsel, for your oral argument and your patience with the board today. That will conclude oral arguments. The record's closed and the matters submitted, and we are off the record. Before you leave, if you would just stop by with the court reporter, pick up your billing sheets. We're in person today, so it's not virtual. OAH won't send it by email. Unless you forget, of course, we'll send it to you. But if you would just have a seat and wait for her to fill out the forms, that would be much appreciated. And then I'll turn it back to Mr. President for the proceedings.
Okay. Attorneys, Dr. Alazadeh, thank you for your time and for being here today. We appreciate it. Thank you.
Thank you.
Do you want to restart the closed session? Okay.
So we're going to take a 10-minute break and then go into closed session. A 10-minute break. Do the roll call. Okay, we're back in session. Can we do a roll call vote, please?
Member Clements,
Present.
Member Dawson,
Present.
Member Sue,
Present.
Member Moreno,
Present.
Dr. Pruitt,
Present.
Dr. Tedder,
President.
Dr. Wong,
Present.
Dr. Bragg present, Vice President Linden,
Present.
President Garcia.
Present.
All right, we are going to get into agenda item number 7. This is discussion and possible action to appoint members to the Dispensing Optician Committee. Just by way of brief background, our sunset bill, which took effect earlier this year, Senate Bill 776, adjusted the composition of our DOC and transferred the appointment power to the board. The committee once had 5 appointed members and now has allotment for 3. At the January 23rd board meeting earlier this year, the board had a discussion and set a timeline and deadlines for recruitment. And at the April 10th meeting, the board provided further directions to staff regarding the process for selecting and appointing the DOC members. A recruitment period was initiated and ended on June 1st, 2026. The DOC work group, which was led by members Tedder and member Dawson, received, it says 12, but I'll make a correction for the record, 13 applications for consideration to appointment of the DOC, and conducted interviews of six candidates. Really just want to take a moment at this point just to thank all 13 of the applicants that submitted their interest for this DOC. Every one of the applicants was well qualified and had great materials. And so really just want to thank everybody for that interest. Also want to thank the candidates that interviewed for the position. Really enjoyed hearing from you all in the conversations that we had. And while some of you may not have been fortunate to get recommended for an appointment this time around, we hope that all of the folks that submitted an application will stay engaged and involved with the DOC. DOC members will cycle on and off, just like board members will. And so please stay engaged, stay interested, especially as the committee gets formed and gets to its work. We would love for all of you to stay engaged and stay involved. Today, what we're hoping to do is receive from the board formal nomination with a motion and a second for the three members of the committee that the work group is putting forward. Those three members, I will say the names of the three members, and then I want to turn it over to our committee members, our work group members, excuse me, for any comments that they have regarding the process. But the three members that the work group is recommending to the board for appointment to the Dispensing Optician Committee are Dr. Michelle Hoff, who's both an optometrist and a spectacle lens dispenser, Levy Barron, who is a spectacle lens dispenser, and member Martin Dawson, who is both a contact lens dispenser and a spectacle lens dispenser, and as you all know, a member of the board. With that, I would, again, as I said, love to turn it over to members Tedder and member Dawson for any comments and thoughts that they have about the process that we undertook.
Would you like to go first, Martin?
Briefly, it was a pleasure, as Greg, Mr. Prudence said, it was amazing to have the 13 applicants. We started off kind of slow, had a couple just to begin, and then as we got closer and closer to the deadline for submissions, we had a bunch of people. And like Mr. Prudence said, amazing applicants. And I really enjoyed our interviews, talking with Dr. Tedder and Mr. Pruden. I really enjoyed myself. So I look forward to what the committee's going to be able to accomplish.
Yeah, well said, Member Dawson. This is Member Tedder. I have a round of thanks for a few folks. I think number one, thank you to the applicants. We were very impressed with everyone that we had a chance to talk with. Like President Pruden said, please stay engaged. This committee this is our first step, and think that this will be a very exciting journey for licensed opticians in the state. So we're very thankful for everyone's engagement, and thank you for the time and the courage it took to submit your applications. Everyone's applications were very impressive. The passion that everyone had for the profession is really pretty exciting and very good to see. Secondarily, wanted to thank Member Dawson. He represented us as a board, as an optician, very well, and it was my privilege to get to know him a little bit better, and I think that him being on this committee is going to be just fantastic. So really, thank you, Martin, for your participation. Also, thank you to board staff. The process of scheduling this many applicants is not easy, and getting the application packets together, getting everyone scheduled on a timely basis was very impressive. So thank you to board staff. But no, just really excited for the two folks that we chose. I think they're going to do a fabulous job in representing this committee and representing this board, and can't wait to see what you guys do. I think it's going to be a very exciting opportunity for us to push this forward, and couldn't be more excited to see what the work entails and what the outcomes are. So thank you.
Thank you both, members Tedder and member Dawson, for your comments there. So as was mentioned, we have three spots. One of the three spots must be a sitting board member. And it was for one of those reasons that we put member Dawson's name forward as a recommendation. One of the things that we need to do if the board is going to make appointments today is we need to also stagger those appointments so that the three committee members don't all term off at the same time. In your materials for this item, I have put together a proposal for what that staggering could look like. But that's up to you guys to determine if you are going to make a motion to appoint the recommendations today. But I just want to make that comment that while staggering needs to happen, the proposal for the staggering is just a proposal, and you all can decide how you want to do that staggering in your motion. Further information, and just to be really clear about all of this, in your material packet, there are suggestions about the recommendations that we're putting forward in terms of what specific spot they would fill. So I want to make sure that the full board is aware of that, sees that, and understands which roles these folks would actually fill. So with that, happy to turn it back over to President Garcia and the full board for further business on this item.
Okay, are there any other comments from the board members? Action item?
This is an action item if the board so chooses.
Yeah, so I'll entertain a motion if someone would like to make a motion to accept the proposed members as listed. Dr. Hoff, Levi Barron, and Martin Dawson.
So,
Do we also want to include the staggered?
Yeah, I think that if it can be done in one motion.
Hear that?
Yeah,
do you want me to make it, or you want to do it?
can make it with a staggering.
All right, so I'd like to propose that Dr. Michelle Hoff be appointed for a 3-year term, which would expire in June 1st, 2029. I'd like to propose that Levi Barron be appointed to the SLD slot, appointed for a 2-year term expiring June 1, 2028. And I'd like to propose that Martin Dawson be appointed to the registered dispensing optician slot, fulfilling the role of a sitting board member on the DOC, and be appointed for a 1-year term expiring June 1, 2027.
Okay, do we have a second?
I'll second.
We have a first and a second. I'd like to open it up for any public comment from anyone in the audience.
Just a very quick thank you. I think it's great. Thank you.
Thank you.
Thank you, Ruben.
Public comment for those online.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Thank you. If we can do a roll call vote, please.
Member Clemens,
Aye.
Member Dawson,
Aye.
Member Sue,
Aye.
Member Moreno,
Aye.
Dr. Pruitt,
Aye.
Dr. Tedder,
Aye.
Dr. Wong, Dr. Bragg, aye. Vice President Linden,
Aye.
President Garcia.
I vote aye. Motion passes. Thank you, everybody. Great work, committee.
Congratulations.
Yeah.
I was just say congratulations, Member Dawson. Congratulations, Dr. Hoff and Miss Barron. You'll be hearing from me soon because now we need to get schedules together and figure out when we're going to meet and begin conducting some very important DOC business. So I'm really excited and looking forward to that. Thank you again to the work group. Thank you, board, for the support today on this item.
Thank you. Okay, we're going to move on to item number 8, which is discussion and possible action on Department Consumer Affairs update. Ms. Salazar, I'm sorry. Come on up.
All right. Good afternoon, members and staff. My name is Lucia Saldivar. I'm the Deputy Director of Board and Bureau Relations at the California Department of Consumer Affairs. I was appointed to this position by Governor Newsom last fall, and I've slowly been making my way to all the board meetings. So it's a pleasure to see all of you this afternoon. I appreciate the opportunity to introduce myself and to also provide a brief update from the department. Firstly, I know that you heard from Secretary Chopra this morning. On May 12th, Governor Newsom announced his appointment as the Secretary of California's new Business and Consumer Services Agency, which officially launched 9 days ago on July 1st. We are so excited to welcome him and look forward to carrying out our shared consumer protection mission under Secretary Chopra's leadership. Next, DCA, along with other state departments, transitioned back to 4 days a week in office on July 1st, consistent with the governor's executive order, which originally was meant to take effect July 1st, 2025. DCA wants to recognize board leadership's efforts and partnership as we work together to support staff on this transition. And some training updates. The next board member orientation training, also known as BMOT, will take place on October 21st. BMOT is an all-day virtual training which must be completed by board members within 1 year of appointment and reappointment to the board. So please register for the first available date to be in compliance. And on May 26th, DCA launched its internal defensive driver training, which is now available on the Learning Management System, also known as LMS. This training is mandatory for state employees, and that includes board members who operate vehicles on official state business. This 2-hour interactive session covers safe driving practices, rules of the road, and required forms for state travel and accident response procedures. Board members can register for BMOT or defensive driver training using DCA's LMS. But if members have any questions on accessing LMS, or if you would like to check to make sure that you're in compliance with any of the mandated trainings, please contact our team at memberrelations@dca.ca.gov. And with that, thank you so much, and I'm available for any questions you might have.
I have one.
Sure.
Is the 2027 calendar for BMOT out yet, scheduled yet?
Not yet.
Okay, so the last date that we know of for sure is this October. Okay.
That's
I
correct.
think there are a few members who may have been recently reappointed
Mhm.
that may need to take that, and maybe that's the one you want to take since we don't yet know when 27 is going to be available.
That's correct, yes. Would highly recommend that those board members take the October 21st BMOT training.
Second question, if I may. Defensive driver, and you mentioned for board members that conduct state business in their vehicle, does that include using your vehicle to drive to a board meeting?
That's correct.
Gotcha.
Yes, it is a required training for board members.
So everybody's going to need to take that.
Any other questions from board members? No. Seeing none, thank you, Ms. Olivar.
Thank you so much.
Thank you.
Appreciate it.
Okay, item 8B, Budget Office Fund Condition, Ms. Molino and Mr. Lancioni.
And members, as they're coming up to the dais, this is in your packet. I think we just may have forgotten to put a tag 8 on it, but it's in there. It's just right after 7, I promise. And staff, that's probably my fault because there's not a cover memo for item 8. We just jumps right into the materials. So don't worry about the sticker not being there.
Okay, good afternoon. My name is Emily Molino. I'm a budget analyst with the DCA Budget Office. I'm here along with Bradley Lancioni, Budget Manager. I want to thank the board and executive staff for allowing me to present on Agenda Item 8BI, the board's expenditure projections and fund condition statement. First, I'm going to start with the board's expenditures, attachment 8BI, page 1 of your materials. These projections are based on actual data through fiscal month 11. This report includes 2024-25 actual expenditures in the green, as well as 2025-26 budgeted and projected expenditures in the blue and orange. As we move to the end of the document, you will see the board had a beginning base budget of $3.887 million in the blue. It's going to be towards the left on the bottom. And it's projected to spend approximately $3.432 million, and that's going to be in the orange down towards the right. This creates a reversion to the board's fund of approximately $455,000 with a reversion percentage of 11.72%. The next document I will be going over is the board's revenue projections, attachment 8BI, page 2 of your materials. This report includes receipts collected through May and projected revenue to year end. I'll go further into the board's collected revenues as we transition to the next slide. The next document is attachment 8BI, page 3 of your materials. This is the board's fund condition statement. As a reminder, we read this document from top to bottom and left to right. The left column is the board's prior year 2024-25 actuals. For current year, the board has a beginning base budget of $3.073 million. The board projects revenues of $3.683 million, with $408,000 from initial license fees, $2.939 million from license renewals, and $336,000 collected from the issuance of citations, fines, delinquent fees, and other revenue. The board's 2025-26 expenditures are based on the Budget Act with FM11 projections at $3.732 million between authorized expenditures and direct draws to the fund, leaving the board with a fund balance of approximately $3.024 million or 9 months in reserve. The Budget Office will continue to monitor the board's revenue and expenditures and report back to the board with monthly expenditure projections as we move through the current fiscal year. Just a few things to note on the board's fund condition statement. The fund condition is a snapshot in time. One of the main factors driving expenditure increases in future years is a result of personal service adjustments. These include general salary increases as well as employee compensation and retirement rate adjustments. The Budget Office includes a conservative ongoing 3% increase to expenditures on the fund condition statement to account for these ongoing incremental adjustments. You will also notice the revenue is projected static in the out years. I would also like to note to the board that any future legislation or unanticipated events could result in the board's need for additional resources, which would create cost pressure on the fund. Again, thank you for allowing me the opportunity to present at today's meeting, and I'll be happy to answer any questions that you may have.
Thank you so much. I would just point out for the members, just in the spirit of being transparent, and we like to be very transparent with these numbers at every one of these meetings, that you'll notice we are projecting a deficit at this time, right? For the fiscal year that just ended. We're now in a new fiscal year. But for the fiscal year that just ended, 25-26, we are projecting a $49,000 deficit based off of these numbers. You may be wondering, well, gee, last year we had a $141,000 surplus. What might account for the deficit this year? A couple things. Higher than normal AG expenses. Now, when I say higher than normal, I don't mean that we're spending more than we're budgeted to spend. I mean that we're spending more than we normally spend. And just as a reminder, we had a litigation and a lawsuit we were defending, which included a settlement. So that right there is more than accounts for the deficit. We've also notified the board at prior meetings regarding our higher than normal expenses for OPES, Office of Professional Examination Services, which is how we conduct our California Law and Regulations exam. And every 5 to 7 years, you need to do an occupational analysis, which is a formal study analyzing the profession, which ultimately will lead to some changes in the exam content. We have conducted that occupational analysis study. It'll be presented at a future board meeting, but that's a study that had one-time higher than normal costs that we don't incur every year. I don't have the final numbers on the third item, although it was projected to cost us about $30,000, which is the website redevelopment of the website and the deployment of the new website. I do know that the final cost number is going to be significantly lower than that $30,000 estimate, but again, that's a one-time cost that we don't have every year. So taken together, my identification of or my analysis of these numbers is led me to identify these 3 areas as being the main contributors that are like one-time items, if you will, that don't occur every year in terms of explaining why we are projecting a deficit this year. So just wanted to be fully transparent about that. And happy to take any questions or comments from the members regarding the fund condition.
Any questions from members? Seeing none. Any questions from people in the audience? Any questions from anyone online?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, thank you, moderator. Thank you to the both of you.
Thank you.
Appreciate the report. Okay, we're going to move on to action item number 9, discussion and possible action on executive officer's report. EO Pruden.
Wonderful. Well, I just mentioned it, but we'll mention it again. So this is agenda item 9, executive officer's report. We're going to start with 9A, which is program update. And I just mentioned it, but the optometry occupational analysis study is complete. I actually just received the final copy of it a few days ago. So this will be presented at a future board meeting. Hopefully the October one, the next one, but definitely at a future board meeting. And as I mentioned, this will lead to development and refinement of our CLRE, our California Law and Regulations exam. I really just wanted to take a moment, one, to let you guys know about that update, but two, to thank OPES for all the work they did. And I know we'll get to thank them formally when they present it, but really appreciate the work that they did on the study. And thank you as well to all of the subject matter experts, the licensees who participated in this study. So I'm really looking forward to this being released. The last time the Board of Optometry did the optometry occupational analysis study was actually in 2018, and it was released in the beginning of 2019. So we're toward the end of that 7-year period. So that's update 1 on agenda item 9A. The second item is just a notification to the board of a fingerprint audit that we were selected for from the Department of Justice. As an agency that has access to criminal offender record information for our applicants and licensees, periodically you will be fortunate enough to go through an audit regarding your process for how you're conducting those fingerprint checks. On May 4th, earlier this year, we were selected for that audit, participated fully in the audit. I want to give a big thank you to Cricket Borges, who's in the room here today with us, was our main point of contact at the staff level for the audit, kept me on target, on task, making sure that we were being responsive and performing the work that we needed to perform. So thank you, Cricket. And happy to report to the board that we were recently notified that we were found to be compliant in all areas assessed. So good news on the audit finding for the board. Item number 3 is a staffing update. Very excited to introduce Christopher Romeo. There he is. He's in the room. He's waving. Really excited that he's with us. Started just on July 1, so brand new. He fills the recently vacated receptionist position that was held by Christina Eklund, who retired recently. This position has frontline responsibility for a lot of admin and customer service support, but he's also going to be directly involved in the Practice and Education Committee courses and applications, as well as helping out with board meeting minutes and things of that nature. So really excited that he's with us and looking forward to getting him onboarded and hitting the ground running. A copy of the current org chart is included in this item. It may have, I'm looking at the materials, looks like I forgot to attach it, but we are fully staffed up with our vacancies that we were recruiting for. So that's the good news there. Just some publications, communications, and outreach. The summer newsletter is in development, and I don't know if Serena knows this, but she'll know it now. I took a quick peek at it the other day, and it looks really good. So I'm really excited to see that come to fruition here soon. We're expected to release it in the next month or so. I came back recently, about a month ago, from the Association of Regulatory Boards of Optometry meeting. Their annual meeting this year was in Phoenix, Arizona, and it was hot. But really good conference. I think one of the highlights that I want to just mention is there's been a big focus the last couple years about examinations and achievement. and how the students are doing. And there was a lot of robust discussion this year from all corners of that world, from the deans that are involved in it, from the testing folks that help administer and put that on, the board perspectives, right, in terms of how those examinations are conducted and the importance of them. So that was a big takeaway, for my attendance this year. And let's see, moving on. Following that, just a couple weeks later, I provided a presentation, licensing presentation to the California Optometric Association, something that we do annually around graduation season. Really fortunate that they put on what they call a new grad webinar, and we're able to talk to those folks. So that was a good presentation. We're fortunate to do that. The last item that I have for you all today on program update is just, again, I mentioned it a moment ago, but the redesigned website is now live, went live last month. Really excited about this new website. We obviously still have more updates and more functionality that we anticipate bolting on and releasing with the new website, but really excited about the way it looks, a little bit more mobile friendly. We're trying to reduce some of the verbiage that's also on the website and just kind of get down to the essential bolts, the nuts and the bolts that folks, the applicants and licensees really need to know. In terms of looking toward the future and some of the capabilities that we're excited to engage with in terms of the new website is some enhanced form functionality, and the ability to directly upload documents via this form functionality and kind of like more of a portal system. There's a few other DCA boards that have been engaged in or have been taking advantage of that functionality, and it seems to be working well. So that's something that we're looking forward to do. But yeah, really excited about the website and thankful for the IT team at DCA for helping us along with that. So that's the update I have for agenda item 9A. Any questions from the members?
I just wanted to say congratulations. I think the new website looks fantastic and much easier to use. And then I also wanted to say congratulations because I too was at the ARBO meeting and Greg was one of the chairs of one of our panel discussions and he did a great job.
Thank you. Any other questions from the members? Okay. Brennan, Council, I don't think there's any action item on any of these. Do I need to take public comment one by one, or can we take it all at once?
Fine, take it all at once.
Okay. All right. If there's no other questions, we can move on to agenda item 9B. And I'm going to do 9B as well because Brad is not in the room with us today.
Okay.
One of the main things you see right here in your memo is just the enforcement trends and the cases received. This was something that we talked about at the last board meeting, that we were trending to a higher caseload this year than what we had in the year past. With the fiscal year now behind us, last fiscal year 25-26, you can see that we had 558 total cases. So we did go up, although not by a huge percent more than last year, but we did go up. You can see quarter over quarter, those numbers are increasing as well. Thank you, Brad, and staff for putting the detail behind some of these increases so the board can see where those numbers are trending. Much like the cases went up, our citations went up as well. So that's a product of the good work that the staff is doing on that side. A lot of the citations, most of the citations are related to continuing education. That continues to be the majority of our citations. But we did have an increase as well on the opticianry side. And again, that had to do largely with the focus on unlicensed activity, as we've talked about in the past with this body. Over the last year or so, staff has increased its activity and its work on unlicensed activity cases and trying to target those and find those. Again, the goal with those cases is not to issue a citation. The goal is to get compliance and get you into licensure. But if we have difficulty with that, we will use the tools that we also have been provided on the enforcement side, which most principally look like citations for unlicensed activity. We also had an increase in the AG cases that we've sent across both programs, optometry and opticianry. So that represents, on the one hand, an increase in our complaints. On the other hand, severity of the type of complaints, right? That it necessitates an accusation or a filing with the AG's office as opposed to a citation, which would be a lower level of sanction, if you will. So increase on the AG side across both programs. Probation monitoring stats and CE stats are also included in this item. We currently have 6 probationers, 5 optometrists, and 1 optician. They're all active. None of them are in a tolling status. And then the CE audit stats are also provided. These are in attachment 9B II. You know, like we've talked about at most of these meetings, the pass rate remains stubbornly too low. We would love to see that increased at every opportunity that I have, including just recently at the ARBO conference. I, make these points and bring this up about CE audits and the importance of them. We specifically talk about the ramifications of such a violation in terms of the monetary ramifications, the fact that it's going to be publicly reported for 5 years, it's going to be distributed in the newsletter, so on and so forth. Would love to continue to partner with stakeholders and others to get these numbers increased because they do remain stubbornly too low in terms of the pass rate. Just to put real numbers behind it, for fiscal year 25-26, the pass rate was 66%, which was exactly the same as the year prior. We did complete more audits this fiscal year, this past fiscal year, but the passage rate stayed the same. That's the enforcement report. Happy to take questions, comments from the members.
I have a question.
Yes, sir.
For our licensees that are not passing the audits, do we know what's the common trend there? What's the rationale?
I will come back at the next board meeting and give you all a full breakdown because it's been a little while since I've done that.
Okay.
The last time I looked, the majority, and it was an overwhelming majority of licensees who failed because they told us that they had done 50, 35, and 10, but did not. They just didn't do enough hours.
Okay.
There are people who have done more than the 50 hours, but have done some of those hours in practice management, business management, which are not accepted by our board. So they will present with, say, 55 hours, but 6 of them were practice management, and now that drops them back down to under 50, and that's a failure. The law does not allow for practice management, business management courses to be accepted. There have been, like I said, several folks that fall into that category. We do outreach and message around that. Many of the licensees use ARBO's OE tracker to track and keep up to date on their CE. When you log in as a licensee to ARBO OE tracker, it tells you what the state requirements are for every state that you're licensed in. And we know a lot of licensees are licensed in more than one state, but it does tell you specifically that practice management, business management is not accepted by California. Our website also says the same. And we have sent that out in newsletters and in other communications as well. But I'll bring a full breakdown. There are also people who have done, 50, 35, but they're glaucoma certified and they only have 8. They need 10. And so there's been, it runs all over the place. But again, the last time we looked and crunched those numbers, a majority of folks who failed because they just didn't do enough hours in one of the categories.
All right. Thank you for the update.
Yep. Questions, comments? Okay. If not, we can move on to item 9C, which is examination and licensing. And Erica is here to give us this report.
Good afternoon, board members. I'm going to give you a short report today. Our Breeze updates, as you know, each month, board staff collaborates with the department to enhance the functionality of the Breeze system. And so the recent updates that we had, April 2026 through June 2026, is newly licensed optometrists now receive an email once their license is issued. The letter was outdated, so the decision was made to remove the letter and to replace the notification with an email. So we're happy to say that that has been completed. For future Breeze updates, we are expanding email notifications of licensure issuance to other license types and permits, beginning with RDOs and SLDs. And then our next update is that we are going to be providing print to download options for renewals. And so the next item is statistical review for quarter 4, fiscal year 2025-2026. For quarter 4, the fiscal year 25-26, the board approved 55 requests for verification letters, 13 applications for retired status, and 0 for retired volunteer status. A statistical review of the 4th quarter of the fiscal year 2025-26 is provided as attachment 9C. Attachment A shows the number of applications received and approved by type. Attachment B shows the total number of licensees by license type and license status. This data is as of June 30th, 2026. And attachment C contains graphs that illustrate the number of applications processed along with the average processing time. These are shown by month and then by quarter. And the data presented is as of June 30th, 2026.
I'm really excited about this print to download option, especially for renewals. One of the reasons why we're thinking about doing it is, one, for costs, so that we're not having to print and mail, because there's a cost to print and mail. But 2, I think it'll just make it more functional for the licensee. We hear all the time from new grads, especially who are newly licensed, right? That they want something in hand, right? And we can tell them, which we do tell them, well, DCA search is real time, right? You can go up there and tell your employer, tell whoever, tell mom and dad, right? You can see it, it's right there. But that's not always good enough, right? It's an online thing as opposed to something in hand, right? So doing that on renewals is where we want to start, because there's a bigger bang for the buck there, but we're excited to what that could look like if it works out for new grads. Because having it in an email, right, or something that you can print, download, then you're off and going. You don't have to wait 2 weeks for the certificate to show up. Again, we want to start with renewals because there's about 4,000 of those every year compared to, say, 300 new grads, new optometrists. The other thing is we need to do some outreach, especially on the initial licensure side, because when you're initially licensed, you receive more than one document. I know all of my licensed optometrists, it's been a while since you've received this as an initial licensee, but you get an engraved document, an engraved license, and then you get a pocket license, one that you carry. And then on renewal, you get what we call the small wall, right? And so it may be more difficult to have a print download option for an engraved certificate, right? Yes, it's engraved. It looks very nice, right? Was yours not engraved all those years ago? Okay.
Dark ages? No.
It's engraved now. So it's really nice, and I think licensees like that. So we're going to start with the renewals. I don't have an estimated date of when this will go live, but it's something we're looking into. We're excited about. We think it can make our operations a little bit more efficient, save us some money, and also just be more modern for the licensee and the applicant. So really excited about that. That was just a comment I wanted to make about it. So. comments or questions on the stats? We also have included the California Law and Regulations exam stats like we normally do. You can see, what those results look like for the entire fiscal year. About 89%, if you're rounding up, of all the people who took it passed. Some of you on the board may recall just a couple years ago that pass rate had dropped all the way to 81%, 80.5, I think specifically, if I remember correctly. Last year it was up around 90, and this year we're at about 80, 88.5, 89% if you round up. So I think we can feel good about those numbers and how our applicants are doing. So just want to make sure that you all saw those numbers as well.
Just a comment on that. I do find it interesting that for first time and repeat, the pass and fail rate is essentially the same.
Yeah. Yeah. Yeah, you're right. It's very statistically significant or similar. I mean, is there any further breakdown of data that you'd like there? Or? Okay. Yeah, because repeaters, there's no limit on how many times you can take it. Unlike, NBEO, which has the 6 or 7 times, and then you got to get a waiver from the dean or what have you. So I know some of these repeaters are on their 3rd time, right? Or maybe even the 4th. They're not all just 2nd attempts.
Great. I had a question about the exam.
Yeah.
When they retake it, is it the same questions each time?
No.
Or there's a pool of questions and it refreshes, so we wouldn't be able to dig in if they missed the same question?
Great question. So if you recall, you used to have to wait 6 months if you failed it to retake it. And I think one of the reasons for that was because that was the cycle that we were on for refreshing the exam. When we were able to move to the 3-month waiting period, and we were able to do that because we were able to, we had a good, robust pool of questions that we could pull from, and we were able to conduct a couple more workshops during the year. We did some recruitment and outreach for subject matter experts, got a little bit better of a pool there, and we're able to conduct some good item writing and passing score workshops. And that's how we build the exam. So it's 3-month waiting period. If you fail, essentially it's every quarter, right? So if you fail the April version of the exam, you're going to wait 3 months and take the next iteration of it. I don't know how different the questions, how different they change over from one exam to the next, but it's not the exact same. That's not the exact same exam.
Item D.
Yeah. If there's no other questions on that item, we can move on. Thank you, Erica.
Thank you, Erica.
Next item is 9D. This is a standing item. I do not have any specific updates on any of the 4 previously approved regulatory packages. I don't think council will be mad at me if I say within this item, that he can certainly let me know, that all of the section 100s that we did and were board approved, that are not on here because they've been done. They've taken effect. They've been approved by OAL. And all of those section 100 the packages that we looked at earlier this year have all, like I said, taken effect. So that is a regulatory update that we have that we can share within this item. But of the 4 previously board approved packages, we don't have any movement on them from the last meeting. 2 of those items are disciplinary guidelines. One of those items is opticianry disciplinary guidelines. And we have previously mentioned to this board that we are part of a work group within the department. There's some exciting and good things happening there. We also have the DOC that's now been reconstituted, And I think they're going to need to look at that language as well once it's ready for them. So I'm excited about that, but I don't have any further updates to share with the board on agenda item 9D at this time.
Could I ask Greg, is there possibly a futuristic looking update in this part of the agenda where you could talk about anything you're hearing that could be coming down the pipeline?
Yes, we can.
And I don't know if that,
Why don't you
if there's
save
anything now
save
that-
that for item 10,
Oh.
future agenda items, and then we can talk about. Yeah, I think yes. Any other questions, comments? Okay, we'll go to item 9E. This is our strategic plan. Just for some background again, because this is, I think, only the second time now that this item is appearing on our agenda as a standing item, and it will continue moving forward to be included as a standing item. But our 26 to 29 strategic plan is obviously in effect, and we have 21 objectives within 6 goal areas. And just as a reminder, those 6 goal areas are licensing and registration, examination, enforcement, outreach, laws and regulations, and admin and customer service. Following its approval, we worked with DCA to develop an action plan and a tracker to help monitor our progress in completing the objectives toward that plan, toward that strat plan. There were 86 tasks to be completed within the 3-year period. And I've attached to this item the completion scorecard and the objective scorecard so you can see our progress so far to date. One of the things I would love if anybody has any feedback or comments at this time or following the meeting is, as this is a new item that we are now displaying and including on our agenda, I would love to get any feedback or comments from members about any thoughts, ideas about how we display it, the level of detail that we may include in the future. Would love to know what would be helpful for you. So for example, in this update, we've just provided the visuals, right? Color coded via goal area, both for the goals and the objectives. But what we didn't include this time, and if this is something you would like to see next time, is what was the specific thing that we did to check that off? We can absolutely include that. It will get voluminous as there's 86 tasks to be completed, and the steps or things that we need to do to complete each one of those tasks might be multifaceted, right? But if that's the level of detail that would be helpful for this body, we can certainly include that. So that's perhaps a discussion point that we could all have. But as you can see from the goal completion scorecard, we're at 38% of goal 1, 14 goal 2, 8% of goal 3, 15% of goal 4, 0% of goal 5, and 40% of goal 6. And then that, again, is further broken out in the next attachment, attachment B, which is the objective tracker. So would love to hear from the members if there's any thoughts or comments about how we should display this information in the future and the level of detail that you may want.
I have a comment.
Yeah.
I think this looks really great. I love the color coding. The only thing I wish is if each objective had a little brief indicator of what that objective was.
Yeah. Oh, okay. Yeah. A
Just say real
descriptive.
quick, yeah, instead of having to refer back to the strategic plan.
Yeah.
As far as that specific objective, that would be great. And then as far as the updates and the goals, I think maybe just updating us each time of what was committed, but not having a running thing, what has been updated since the last time that we received
Okay.
the update.
Okay.
But I really like this.
That's great feedback. Thank you. Anybody else? Remember, Brad got it all, captured it all, huh? I'm just writing my notes down so I don't forget. Bear with me. Okay. Okay. Are there any other comments or questions from the members on item 9E? Okay.
Rolling along.
Turn it back over to you.
Okay. Okay, agenda item 10, future agenda items. I think Member Tedder might have had something, and anyone else have any ideas? Let's go ahead and get those out.
We do.
Public comment
Oh,
for.
I'm sorry, back up. Okay. Okay, so we're going to do public comment for all of item 9, the discussion item. So we'll do, for anyone in-house that would like to make comments, please come on up.
Thank you for reminding them, because I had something in mind. Greg, commend you on that website. It's beautiful.
Thank you.
And lack of my research, because I just breezed through it, I was wondering, there is a place where we can guide our SLDs and CLDs about fingerprinting, where they can get that application on the website?
There is a dedicated optician tab on the website, but I just don't recall off the top of my head what the level of detail in terms of fingerprinting is. There should be information on there that directs people to contact us. We don't provide the live scan form online any longer. So you have to contact us to get that.
Okay.
We can look into the optician page and make sure it has all of the clarity for that. But that's what it should say, is to contact us to request either the hard card or the live scan, whichever one you need.
Okay, good. And then just my last point, we do pay attention to the dispensing optician guidelines, and hopefully if there's any education we can provide for that, we'll look forward to that. Thank you.
Thank you. Anyone else from the audience? Seeing none, we're going to open it up for a public comment online.
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click the raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Thank you, moderator. So we'll move on to action item number 10, potential future agenda items. Any members have any comments or ideas?
This is Member Tedder. I think two things. Number one, under 9D, the regulatory update, it would be great if we could get a forward-looking view from President Pruden on anything coming down the pipeline that may be interesting to the board. And the second suggestion is one that I've thrown out before around having ARBO come in and do an update.
Yep.
I'm particularly interested in if there's new technologies or ways we could track CE.
Yeah.
So I think that would be interesting overall for an update from them.
If I could just respond to that second item, I'm actually blanking now what our strat plan says. It says one thing in our strat plan is to have either ARBO or NBEO, if not both, come and speak before the meeting. And when I was just out in Phoenix, speaking with both sides, it was something we talked about. Is getting that scheduled soon. I'd love to have NBEO talk to the board about their examinations and the importance of that, and that's the whole process, as well as ARBO and OE Tracker and CE. So thank you for bringing that up again. It's something that we want to do. We've already had some preliminary conversations, and we'll get it scheduled.
Any other future agenda items from the board members? I just wanted to thank the board members for a really good meeting today. It was very robust. A lot of great discussion, and I really do appreciate everyone's comments and feedback. It's very helpful. So it's a good meeting. I want to thank all of staff that are participating here and present today, and all of those that are back in their offices for keeping the board running and working so efficiently. We really all appreciate it. We know you do a lot of work, all of you. Thank you. Over.
Yeah, the only other item I wanted to bring up is our next meeting is October 23rd. That's a Friday. We're still trying to pin down a location, but I've also been made aware that there may be some conflicts. There may be a big continuing education event happening that weekend. I'm just wondering if any of the licensee members have a conflict with that date. You have a conflict, Lillian, you have a conflict with the 23rd? Okay. Anybody else? Jeff?
Yeah.
Jeff does. That's 2. Anybody? I'm just thinking of quorum, obviously. Okay. So we'll 2 members down for sure. Quorum should still be okay. We'll talk after the meeting and see about that day. Like I said, we're still trying to pin down a location for that. The October meeting, we started last year taking on the road because school's back in session. It'd be great to have that meeting on the road, but we're still trying to find that location, and we'll take note of the conflicts and follow up soon about that.
You want to propose another date, or you're going to just put it on the table?
Well, I'm not worried about quorum with only 2, but because we also don't have a date and we're trying to, or a location, we're trying to take it on the road. We have plenty of time.
Yeah. Anyone last things? No. Okay. Anything? Okay. Looks like we're ahead of schedule. So I'm going to end the meeting at 2:43. Thank you, everybody.